Well, hi, welcome to today's podcast of the legal perspective. The podcast focuses on Pakistan's recent strategy to apply for Reko Diq's annulment of $6 billion based on a recent Spanish case in which the arbitrator that was involved in Pakistan's case, Dr. Alexandrov, failed to disclose some important information. But before we go into a brief summary of the Reko Diq as a whole, I would like to introduce today Mr. Quinn Smith joining us live from USA. Mr. Smith is a managing partner at GST LLP, which is an international law firm with offices across the US and the UK. Mr. Smith has acted as both as a counsel and arbitrator before a number of arbitral tribunals, including under the rules of ICC, ICDR, ICSID, UNCITRAL, and FINRA. He was also involved in the Reko Diq case during the quantum hearing and cross-examined all technical experts. And GST LLP was at large the main counsel for Pakistan during the Reko Diq case. Before we go on and move on to Mr. Smith for his opinion, we would like to provide a brief summary as to what the Reko Diq saga is, the whole thing. So the Reko Diq case, firstly, Reko Diq is a small town here in Chagi, Balochistan, which is one of the provinces in Pakistan, and it is one of the largest the world's fifth largest gold and copper mines here in Balochistan. So Pakistan's, that is Balochistan local government, provincial government in Pakistan reached an agreement with an Australian company, Tethyan Copper Company, and the agreement was a joint venture agreement under which TCC was going to explore the Reko Diq area for gold exploration. And after that, the idea was that they will get a mining lease license for her to then mine the gold for the next number of years. However, after successfully doing the joint exploration, they explored the area, but around, I think, 2010 and 2011, then the Balochistan government did not grant it the lease to mine the Reko Diq area. TCC moved on in front of the ICSID, which is the International Center for the settlement of investment disputes. Well, the case went on for almost 8-9 years, and then ultimately in last year, in 2019, around this time, ICSID provided its decision in which they granted TCC around $6 billion, well, $5 billion plus the interest rates and other rates that came up to around $6 billion. And Pakistan tried to annul these decisions, but ultimately failed. And recently, there is something interesting came into the spotlight, a ray of hope, that is that the same arbitrator which acted for the claimant in ICSID in the current Reko Diq case, that is Dr. Alexandrov, is from Bulgaria. He was one of the arbitrators for the claimant. He was also involved in a parallel decision that involved a Spanish, that involved Spain and an Eiser Energy company, which is London-based asset managing company, and Energía Solar Luxembourg. So they were in a dispute in which those two companies won $128 billion against Spain, and then they ultimately applied for annulment, and Spain succeeded in this annulment based on the main reason that the same arbitrator, Dr. Alexandrov, failed to disclose the information about his relationship with Betel Group. So that is the whole reason that it has become interesting, because it's the first time ever such thing has happened in ICSID's history. And for that reason, we have today joining us Mr. Smith, who will provide kind of his view as to are there any chances for Pakistan to succeed because of this recent judgment. Over to you, Mr. Smith. Thank you.
Hello, Israr. Thank you for that introduction. It's wonderful to be here with you. You definitely gave a very long and complete description of the case. There are a few things that we'll touch on. I think one of the most important is that we got involved at the quantum stage. So we weren't involved for jurisdiction, liability, and corruption. So those all happened before us. And strangely enough, TCC actually asked for $9.1 billion. And they only received 4. I say only, not that that's a small number, but it was 4 and then 2 in interest. You asked about the Eiser case. And I think that the Eiser case is really part of a growing shift to greater accountability for arbitrators. You can see that with the Blue Bank decision, Blue Bank versus Venezuela, a case that we were involved in, where an arbitrator was disqualified due to his conflicts of interest. That was a first. And then now you see it in the context of annulment, where Dr. Alexandrov was found to have maintained an improper relationship with an expert firm called Brattle. And really there's 2 parts to that. One is the relationship that he had with Brattle, and 2 is whether he should have disclosed it. And the Eiser committee found that the relationship was improper and that it should have been disclosed. And just to give one note on the Eiser decision, it involved a very prominent Pakistani lawyer as well. So there's a Pakistan connection in that one, although that would be more coincidental than anything else.
Well, thank you for that summary. And you raised 2 important issues. And the first main one is the disclosure of information, which although they clearly said in the Eiser case that it was important, and also I think one under Article 52 of the ICSID Conventions, one of the 5 grounds is that such information should be disclosed, and it can be a ground for annulment. But now, how do you see this judgment affecting Pakistan's Reko Diq judgment, given that Dr. Alexandrov was also an arbitrator in that case? Do you think there is any hope for Pakistan to get an annulment?
I think so. We are always hopeful. We operate from a perspective of hope. As lawyers, we try to be optimistic about our cases, and so we do think that there is hope. I also think it's important to remember that Pakistan was the first country to raise this problem with Dr. Alexandrov. We first raised it in July of 2017 when we challenged Dr. Alexandrov, and then later Spain took that same information and challenged Dr. Alexandrov in Soles versus Spain, and then the award was issued in Eiser, and Spain sought annulment based on the revelations from this Reko Diq case. So Pakistan has played an important role in this process, and we hope that continues to an annulment in TCC.
Well, although you say that there is hope and we should be hopeful, but then there comes the important question that you already repeated, that Pakistan had already raised this issue in 2017, but they failed to succeed. The same issue that Dr. Alexandrov had a relationship with Battle Group and using the same valuation method. But that makes it a bit separate from, distinguishes it from the Spanish judgment in the sense that in the Spain's case, this was not raised at early stages, A, and B, the second difference that arises here is that in Spain case, this has come after the decision was already made, and information comes later, whereas in Pakistan's case, that was already disclosed. So how much of an effect do you see? Because it has already been gone through the processes in Pakistan case, and they knew it, and Pakistan did not succeed in convincing the arbitration and the tribunal at that point that he should be disqualified.
Well, those are 2 very good questions, and I think if you read the Eiser decision, that's one of the things that committee was concerned with as it relates to to TCC versus Pakistan. But there is a distinction, a pretty clear distinction, and that is that in Eiser you see references to 15 cases. Dr. Alexandrov disclosed 15 cases to Spain, and those 15 cases helped Spain and then later the committee to understand what Dr. Alexandrov was doing, who he'd worked with, and what the cases were. Those cases were never given to Pakistan. And Pakistan asked multiple times. And Dr. Alexandrov refused to provide that information. So I can't tell you what will happen in this case, but there is a difference, and that difference doesn't come in the Eiser decision, which isn't anybody's fault in the Eiser case. It's just because Pakistan wasn't involved in the Eiser case to inform that committee of what actually happened. And really, I think in TCC, you see something that is just as egregious, if not more so, because Dr. Alexandrov just flat refused to ever give Pakistan the information that would have allowed it to evaluate and the challenge and to make the challenge fully and appropriately.
And this raises another important issue when it comes to particularly exit arbitrators. Do we think that the current exit convention rules are clear and precise enough to kind of distinguish and bring forward the information needed from arbitrators, and B, whether when you see there are a couple of conflicting judgments on same issues across exit's history, and that is not the first time. What do you think of in that sense that this judgment in particular sets some kind of standards for further judgments that has to come?
Well, you mentioned something that has been the concern of many states, and not just developing states, but developing and developed states, and that is the lack of precision regarding the requirements of disclosure and the inconsistency in judgments or decisions. And you can see those concerns reflected right now strongly in the United Nations Committee on International Trade Law. And this is it meets twice a year. Pakistan has been very active. Pakistan has been raising these issues and has found significant support to create guidelines at a minimum, such that these kinds of issues are better dealt with beforehand, not afterwards, and not after states have to be held liable for hundreds of millions, if not billions of dollars. So that's the first thing that I think you're going to see as it relates to this specific issue. The second thing that you raised goes to the meaning, or what the Eiser decision can foretell. And on that, you raise a good point. Decisions are not precedential, as many lawyers in Pakistan and the U.S. understand precedent. They can be persuasive. The Eiser decision, I think, will be persuasive. It is well reasoned, and I think it draws on a tradition where there have been numerous decisions like this in the past. Maybe they weren't widely followed or widely studied, but there has been a concern for many years about double hatting and about issue conflicts. And Eiser brings that to a head, makes it public, and gives a warning to other arbitrators who want to put themselves in the same position as Dr. Alexandrov.
I mean, yes, that is, I think, very important and a good way to put it. And indeed, I personally think it will be persuasive, although we do have a history. We know that exit decisions are not binding on other exit tribunals, and there has been inconsistency in the past. But yeah, hopefully it is first time such decision has come in place and will be persuasive. But kind of for the people watching and who will be watching this, would you like to kind of like walk us through the process as to what Pakistan will do now and what is involved and how long will it take? Because these things takes time. The exit its own case started around 2011 and the final judgment came in 2019. And it's not just Pakistan's ones, all of them takes time.
Yeah.
And
Well,
a lot of money is involved at every stage of the process.
Yes. Yeah, that's also true. These are big cases. They demand a lot of attention and a lot of time. I can speak to you generally. I mean, specifically, I of course can't. We're not at liberty to reveal strategies or tactics, but certainly, I mean, you talk about how the process works. And most annulments, they take 2 to 3 years from the time that the request for annulment is filed until there is a decision on annulment. So that's your normal. It was filed. It was actually registered in 2012. It was filed in 2011, registered in 2012. So it was about 7.5 years from the time it was registered until there was an award. That is a little bit on the long side. But if you look, you'll see that many cases are quite long and quite detailed. I mean, the Karki case was registered at the beginning of 2013, and that award came out, I believe, in August 2018. So you had over 5 years for that case, about 5.5 years for that case, and that's really pretty average.
Yes, it is. I suppose 3 years period is actually, I would say, small for the time period we know exit cases take. I would just like to quickly touch again in terms of exit. And you mentioned earlier something that one of the concerns is not only for developing countries, that is the inconsistency in exit decision, but also other major developed countries. However, we have seen majority of the cases, if you go into the UNCITRAL digest and other investment platform digests, they provide kind of the ranking. Majority decisions have always been against developing countries. Well, each case is, I suppose, different based on its own facts, but there is a general consensus among experts and academics the way exit has shaped in favor of investors. And this criticism has also led to now a view of bringing reforms into exit. And in your view, what kind of reforms do you think are necessary? We have examples from the European Commission thinking of an investment court. Do you think that exit with the current pace will have a successful future, or do you think there is a need for international investment court?
Yeah, as it currently stands, I mean, ICSID does need reform. I think ICSID has recognized that with some of the recent changes in the rules. So, yes, it needs reform. What that reform might be, there's a number of things. One of the more appealing options right now is an appeals mechanism. There's so much money on the line. These cases mean so much to countries, especially developing states, who don't have $100 million just to give to an investor, and there is no way to seek annulment based on an error of law. So you can have an error of law, and the award can still be affirmed, not affirmed, but the award is not annulled, and that's troubling. It's really troubling for the amount of time and money spent that a wrong award can still create liability. So that's really one of the key things. I would like to see personally other reforms that would go even further. And this is something where, of course, I'm speaking totally in my own individual capacity. These are just my own personal thoughts. But I would like to see damages caps. I think that in order to get these really big numbers, we need to have greater rigor, and it needs to be for really the most excessive of cases. I know that damages caps are difficult to implement, that they are hard to do, but at the same time, I've seen it done in other fields that are not arbitration. And it has been very effective because it takes your speculative cases and it removes them. And once you get rid of the speculative cases and the numbers get more serious, then we're having the kind of debate that we should have, as opposed to one that incentivizes claimants to go for really big numbers, knowing that they're going to get at least a third. And that doesn't help the system. It doesn't create accountability. It doesn't create consistency. Really, it creates a reward for speculation.
Well, I think that is true, and particularly I would agree with you on the damages cap. Although it's hard, but we have seen huge penalties awarded. Pakistan case is a prime example of $6 billion, whereas the only investment made at the time was way less, around in millions. And I think that is an important reform among other reforms. And hopefully we will see, I suppose, some reforms ICSID has taken into consideration. This now brings me into more of the concluding kind of remarks for this podcast. That is, firstly, in terms of this whole annulment process, again, I will kind of like ask you, do you think there are good chances for Pakistan? Should Pakistan be very hopeful or not that much?
These are always difficult questions to answer. I think as a general rule, we should always be hopeful. We should always be trying to look for a way to be successful. I'm not going to raise hopes or raise expectations. I don't think that's fair to anybody. I think that we need to be level-headed, serious-minded, and but at the same time hopeful. And through that, that's how, in my opinion, you get a good strategy. That's how you get a good way of looking at the case. And and that's what we're going to do. We're going to always fight as hard as we can for Pakistan, and we're going to put our best foot forward, and we're going to stay up late, and we're going to work on the weekends, and we're going to do everything that we can because we want to deliver a good result.
Well, thank you very much, and that is all needed. All you need to put is the hard work, and the rest you have to see. And I agree with you. You cannot see a definite answers for such questions. Well, thank you very much for joining us today for this podcast, and hopefully, good luck with the case.
Thank you. No, it's a great honor to represent Pakistan. We're very proud to do it, and we've met a number of really wonderful people, and we are hopeful that we can share in a success in the future. Another one, actually.